Welcome again to another one of the CE Family Law Conversations. And again, I'm speaking with Diane Loveday. Thank you very much for joining us today.
Thank you for having me, David.
And so one of the things that I wanted to speak to you about is trying to keep matters out of the way of lawyers, and particularly to do with children. And so one of the things we're going to talk today was about FDRP. And from my perspective, quite simply, parents being able to make good decisions about their children is best done without having to have lawyers involved. Certainly, there are a set of responsibilities that parents have, but in terms of coming to an arrangement for their children, which is good for their children, really the court is the last option, clearly. And so if you think about it, and I'd say to parents, there's nothing in the Family Law Act that tells you how to parent your children. It really just tells you a process for someone whom you don't know, called a judge, who will try and do the best job they can to make a decision about the children. So I have no doubt at all that the best decisions for children come from their parents, and indeed the most durable outcomes come from parents. So what I would do very at the outset in the first meeting is talking about speaking with someone who does FDRP. So that's really where you become involved, Diane. Yes. And I thought we should talk about what that means from your point of view, that I would say to them that to go and speak to you, Diane, and then if you could say to me what the process is from that point of view once they contact you.
Okay, so the moment somebody reaches out, I would spend quite a bit of time having a conversation about, often they don't know what we do. You know, it's often a bit of a, bit of a mystery that we even exist. So I explain who we are, why we're here, that we are part of the family law process, and that, we are mandatory for parenting matters or through the Family Law Act. And I invite them in for what's called their intake interview. So it's as I said, it's a very simple process, but it is a prescribed process. So no matter who they see, this is the process. So they come in, have an intake interview, and from that, then I would invite the other party to attend. And there is this requirement in the Act that I should invite the other party to attend, even if it is a mandatory process.
Okay, and how does that happen? So how do you contact them? So if I referred someone to you, spoke to them, and they now want to make contact, or you want to make contact with the other parent, how does that happen?
So I get as much detail as I can at the intake interview. So I'll get names, addresses, phone numbers, and emails. My preference is often to send a snail mail invitation, because people end up with a copy of my Regulation 28, which is a document that explains who I am, how I fit in the family law process. It has it's a requirement of the AG's office, Attorney General's office, so it has our fees. It has a whole bunch of information to help people understand that we are part of the family law process. So I send that. I send a document that explains what is family dispute resolution. So I outline as best I can all the variations, and then sit, and I've got to give them 7 days to respond legally. Okay. All right, so that's whether I do it by email or by snail mail. I've got to give them 7 days to respond. If I haven't heard back in 7 days, I follow up with a phone call.
And lawyers don't have to be involved at this stage at all. The other party doesn't have to have a lawyer to engage with you.
No, not at all. Our preference is, especially in this early stages, as I think we've had this conversation, is that we try and keep lawyers at arm's length for this part of the process, because I just find that it is just far more successful if we are able to just get the parents in the same room, or on a video call. My preference is always in the same room, and having a conversation in relation to the care and well-being of their kids. And they know their kids much, much better than I do and you do. So you're right, they are the experts on their children. So how can I help them become good co-parents?
Yeah. And one of the cornerstones of the work you do is confidentiality.
Absolutely.
I just think we should just talk a little more about that and what that means, because that's really important to the process of parents being able to talk.
Absolutely. So at the intake interview, I will explain to each party individually that this is a confidential process, which means that they can have a frank conversation with me and not worry that the information is going to be weaponized in any way, shape or form. Equally, when they come together to mediate, any information shared in that process cannot be used if the couple end up going through litigation. So you can't, that my notes can't be called into evidence. The intake cannot be called in. I can't be called to give evidence. I love that aspect of what I do. But so it's a completely confidential, contained process that enables them to have a frank, managed, and importantly, safe conversation around what's in the best interest for the care and well-being of their children.
Yeah, and I think it's really good too, because part of the process for parents is being educated about what it means for their children and what they're going through. And one of the things that I'll say to parents is that you don't have legal rights. Your children have legal rights. You as parents have a set of responsibilities. And that's what we need to focus on when we're talking about your children.
I say exactly the same thing, David. And I will quote the International Convention of the Child, which is now part of the family law process. I will talk to them about the changes in the legislation. So we've moved away from shared parental responsibility to a more negotiated responsibility. I talk to them about all of those aspects of how they can utilise this process to find out what's going on. I mean, it's a great way to find out why sometimes the relationship ended, or what are the underlying issues. Not that we're counsellors. It's an important point that we are actually forward focused. So we are not counsellors. We're not here to counsel, but sometimes it's helpful to know what are the sticking points, the trigger points, the things that I need to manage for, because I am bringing both parties together into a room and it can potentially be volatile. So I need to understand what I'm managing for.
Yeah. And can I say, you've actually touched on something that's really important, and that's a big distinction from my job. I get one person's side of the story.
Yeah.
And that's not to say they're wrong, but I don't know what the other person is saying. You actually get to hear both sides, and that sort of that information about the children will actually help you reality test, consider different options, which I as a lawyer don't get. I mean, I can challenge and question, but I haven't heard the other person. And I think that would be one of the key advantages that you've got in your role.
Oh, I completely agree. Yep. And I will point out to clients that, I do get to hear both sides of the story, and I'm one of the few people that do. But I also point out to them that each of their perspectives are valid. I'm impartial. I'm not here to take sides. I'm not here to test evidence. This is not an evidence-based space. We're a goodwill space. So I'm here to help them have their conversations, but I explain to them that I absolutely understand that whilst each of them has their own set of ideals and beliefs around what happened, their perspective, that the truth sits somewhere in the middle.
Yeah. And lawyers from our side of things can sit in the process by making sure that, to the extent it's necessary, they're aware of the law, but I think also importantly aware of the limitations of what the law can do. The law you can't get orders for common sense, intelligence, and insight. And there's a prospect that with you that by allowing them to hear the other person's, what the other parent's saying, to be able to allow that to occur. The other thing is important to know about the delays and costs that are involved, and really the number of times that people have spent private school educations on their children in the courts when it would have been better spent on their children. So it's certainly lawyers are important from that point of view, but I agree with you that we really only need to become actively involved if other processes to work out arrangements for the children don't work.
Yeah. And we are the first ones to encourage people to seek further help if the process fails. But of course, understanding that the process isn't a one-off shop, it's not a one-stop process. Sometimes it takes more than one session to reach an agreement. Sometimes, and it's one of the beautiful things about what we do, is that a parenting plan, which is what we produce, is quickly and easily reviewed and altered if what they agree to initially doesn't work. So they can easily come back and change it and it not cost them an arm and a leg, and it can be done very, very quickly and easily. Obviously, though, there are situations where, especially at the outset, when people are initiating the process, that the other party is not necessarily all that open to attending mediation, or they're concerned, where there's family violence, or even they just feel, the power balance is out. Yes. That they can sometimes be very reticent to engage. And again, it's my role to one, explain the consequences of not attending. So we are the ones that issue the certificate that enables litigation to proceed, and a party not attending constitutes an issue of me issuing that certificate if the other party requests it. And it's important to know that you can't. So sometimes people will try and delay the process, or they will just be a little less than upfront, and they will decide that no, they don't want to use us, they want to use a different service, or they want to use a government funded service, which is all well and good, but the legislation says one party initiates and the other party has an obligation to attend. So if they don't attend, it's my practice that they're not attending. So it's then at my discretion and at the other party's request whether or not I issue the certificate, whether or not my party too has booked in with one of the government fundeds or not. It's often a delaying tactic to book in with the government fundeds, because they have a 6 to 8 week wait for the first intake interview, whereas we can generally see people within 14 days is a long wait for us.
And can I say that's really important? So often interim proceedings begin in court because people can't work out things immediately. And the opportunity to talk about the arrangements really does give a wonderful means to be able to try and avoid the necessity of court proceedings. You touched on violence a little earlier. Can you do FDRP if there's an intervention order in place?
Provided the intervention order it's generally around clause 8 or 9. There's a section that says what the respondent can do, and mediation is 9 times out of 10, and depending on which court, listed there as something that they can do. So yes, the short answer is yes. Okay. And it's important to know that the agreement reached in mediation complements your intervention order. So despite the fact that children might be listed on the order, we can still mediate and put in place care arrangements for the children. Cannot change what happens between mum and dad, though.
No.
Just
kids. Okay. As is so often the case, we're almost out of time, but there was one other thing that I just wanted to ask you about, and that is the children. Is there within your process or another process that allows the child's voice to be heard or brought to the parents to assist them? I mean, children shouldn't be making decisions about the arrangements, but their voice, depending on their age and maturity in the issues, can be very important. And I just think you could just talk a little bit about how that can happen.
Absolutely. So we offer what's called child inclusive process or child inclusive mediation. And I have been doing that for 15 years because the voice of the child is important, and how that is managed and dealt with is very, very important. So we use only trained CIP practitioners who have psychology or therapy backgrounds, and the children have a conversation off-site with their own neutral third party, which is what I'm classed as, and that person then becomes the voice of the child in the actual mediation process.
Great. Diane, it's moved so quickly again. Thank you very much. And I think what would be good if we perhaps talk about this in the context of financial matters, maybe next time we catch up.
Yes, we can do that. Absolutely. Thanks, David.
Thanks, Diane.
Thank you. Bye-bye.